Adjournment request, if any, from item number 1 to 4. From item number 5 to 17, adjournment request.
Yes. May I please, your lordship? Lordship, I beg to mention item number 5, my lord.
Yes.
On behalf of the appellant, that I am seeking an adjournment for 2 weeks, my lord. I have taken the consent from the respondent side.
As prayed for on behalf of the appellant and consented to by the respondent, the matter is adjourned to so and so.
15-9.
I'm so obliged, my
Please, your lordship. Item number 12 here, lordship.
12.
Matter 12 mile.
Yes.
Matter may be adjourned for a week, your lordship.
You are for
Maybe
the
fixed on
appellant.
4.
You are for the appellant.
My lord.
As prayed for on behalf of the appellant, re-notified so and so date.
Master.
17-9.
May it please, your lordship. Lordship, I'd like to mention item number 10 for adjournment, lordship.
10. Yes, you
Yes.
have circulated.
Yes, lordship.
Yes, as prayed for on behalf of the appellant and consented to by the other side. The matter is adjourned to so and so.
19-9.
The other side nearly respondent.
From item number 18 to 28, adjournment request.
Item number 20, Lordship, I'm
Item
appearing for
number
20.
20.
Lordship, I'm appearing for the state respondents. Lordship,
Yes.
I'm praying for adjournment of this matter for 2 weeks, Lordship. But my,
Have you informed the other side?
yes, Lordship, yesterday evening I informed.
Again, a prayer for adjournment has been made on behalf of the state after informing the council for the re-notify this case on so and so date.
17-9.
Lordship,
Keep a calendar such that it's not more than 29. But you can take 57 to. Don't make it more than 30. So, go beyond.
Yes.
Item 25, your lordship.
Yes.
I appear for the petitioner. The respondents in the forest department has filed their affidavit yesterday in the afternoon. I need to file a reply, and I have also gone to the records. The affidavit is also not on record yet. They provided the roadmap.
As prayed for on behalf of the appellant, re-notify on so and so day. Some other day.
A pleasure.
22-9.
May it please, Lord. I beg to mention item number 30, 31, and 32. I've taken the consent of the other side, Manoj. I need 2 weeks time to file my affidavit, Manoj.
Some urgency on our part, my date, early date.
So there's that Sikkim matter.
No, my lord.
No.
Supplementary. Item number 30, 31, and 32, my lord.
Item numbers?
30, 31, and 32, my lord.
Where is the supplementary list? Here. Okay. Paul. As prayed for. As prayed for on behalf of the
State, my lord.
state, re-notify or give a date after.
15 October.
Obliged.
Any other request?
May it please your lordship. Lordship, I beg to mention for listing of one writ appeal, lordship, for tomorrow, lordship, if your lordship.
Listing of?
allows. One writ appeal.
And
For
what is the
tomorrow.
urgency?
Lordship, actually, there has been a series of litigation in this matter. First of all, the writ petition was for a simple, limited to a simple prayer of correction of the date of birth of the petitioner in the service book, lordship, which was allowed. Then, lordship, subsequently, a determined order was passed by the authority concerned, based upon.
On the basis of the rectified date.
No, on basis of the wrong entry.
How can that be possible if
Yes,
your
Lord,
prayer was
then-
allowed?
Yes,
If your
lordship.
prayer was allowed and the date of birth was changed, I think your
That is what
retirement would have been
lordship-
counted from that date.
That is what lordship, then subsequently the writ petitioner again challenged that order also, that order for retirement. Then after some series of reviews and all, the retirement order was
Recalled,
not cancelled.
resigned it.
Yes, lordship. So this writ appeal, lordship.
No. urgency.
Because recovery.
That's all right. Tuesday, Wednesday, anytime.
Next week.
Next week. Not tomorrow.
Deeply obliged.
Yes.
Daily list for orders item 1.
My lord, in response to the order dated, my lord, 24/7/25, the registry, my lord, spared this, my lord. This is the communication made to me, my lord, just to place before your lordship.
May it please your lordships,
Yes,
at the very outset, I take this opportunity of, I'm grateful to the honorable bench for having afforded me this opportunity of arguing my matter.
Mr. Gyani, can I request you to take your seat and address us?
My lord, I'm grateful, but I may remind your lordships,
Yes.
the great lawyer, Mr. Parasharan, while arguing the Ram Janmabhoomi case, he was also offered. Of course, I'm not equating myself to that great lawyer. And he said I would, and he kept arguing for days together before the bench,
No, no, that's
standing.
right. We are
Maybe
not-
I have undergone bypass. I have recently been discharged from the hospital on
We are not doubting your physical abilities.
My
Out of,
lord,
out of,
I'm
out of
really
our,
grateful.
out of
Now,
our respect for you,
with your
we
kind
want you to
permission,
take your seat and then address us.
I'm grateful, and with your kind permission, I take my seat so
Yes.
that I may be able to make my submissions
That's
in
right.
a manner which may be quite conveying and not convincing, I can't say at the moment. But let me, at the very outset, again thank. This is not my maiden appearance
Yes.
before this august bench.
Hmm.
I've been, as a lawyer, appearing before the former Chief Justice who eventually went to the Supreme Court, Justice Saikia, then Justice Manishina Singh, dealing with habeas corpus petitions. This is perhaps the fourth or fifth time that I am appearing, of course, not for any client, but for myself. This was at that moment, I never could think of that someday I would be sitting and hearing other. I had the opportunity of hearing the great
Mr.
Ram
Gyani,
Jethmalani, Arun Jaitley, and Rajen Satcher, the former Chief Justice of Delhi High Court. They had been coming arguing these matters. Kindly, I mean, I'm really grateful for having afforded me. Now coming to the task that we are facing, we have traveled a long distance,
yes.
right from that 1871 Act, Pension Act,
Hmm.
and from Devkinandan versus the state of Bihar.
Can I just request you to go through the communication sent to us by the Registrar General? Have you given it to us?
Yes, that's my, yes, that is one, this.
This is the one.
Yes,
What does it? Just a minute. Can I just take 1 minute? Yes, Mr. Mantha. What is there?
yes, that is my lord, dear lordship, my lord, that the act, the domestic help act was coming, rule was coming to force in the 2021.
Yes.
Bill has been paid, my lord, already, that is flag 1A and B, my lord.
Whatever is due to Mr. Gyani has
Yes, my
been paid
lord,
to
that
him.
is.
With the increased slab, 20% and 30%. 30% became
30% has been paid.
No, that
And
part,
been paid, but not from the date for which I had been. The crucial question that lies whether that slab on the date of stepping into the 80th year, that for that this honorable court has decided. The Union of India with other parties went to the Supreme Court in SLP, which was dismissed by the Supreme Court. And even after dismissal, it took more than 1 year and 77 days for these authorities and that particularly respondent number 5 to give it, I mean, really enforcement of that order. And it can't be said that it is not without this disobedience and defiance of the court's order, waiting for the dismissal of the Supreme Court. And in the meanwhile, none of them, as is the usual practice, pending appeal, grant stay or anything of that sort, none of them appeared before the court. And the petition was necessitated because of the reason that the Registrar General, in my earliest, first took that it is payable right from 2015, July 2015. Then the Department of Justice sent a communication. No, it is on completion. It is, it, the real clash, whether on commencement of the year or on completion of that year. Now, this is the two things. I have just applied even for the 40%. I have completed, third slab, now that 40%, and the Registrar General, Accountant General have been endorsed and forwarded with the copies which I submitted to respondent number 5.
All right.
No reply. Now,
Can I
no
just-
communication.
Can I just interact with the counsel for the High Court? Just wait for a minute, Mr. Gani.
Thank you,
Just
sir.
wait for a minute. Now,
Thank you, thank
he
you.
says that you have paid the first slab on his coming of age of 80 years, and that date is 30/7/2015.
Yes.
From what date have you given?
That part, my lord, probably, my lord, AG, because your lordship kindly, I am only, my lord, the order dated 24/7/2025. Regarding, my lord,
Well, that's a very limited, approach to what we want you to do.
my lord.
Now you have to tell us, after liaising with the Accountant General's office, that the pay 20% slab
My lord,
he would be entitled to when he enters the first day of his 80th year, which is 30th of July 2015,
then, my lord, I have to.
and whether it has been paid.
Because-
And 30% slab, 30% increase, that would be payable to him from 31/7/2020.
My lord,
Now he says that now 40% when he enters into his 90th year.
My-
Now you have to give us specific statement after liaising with the Accountant
My lord,
General's office, and you have to do it fast. We can't make Mr. Gyani
My
wait like this.
can
It
be-
doesn't look nice that an acting Chief Justice,
My lord,
former acting Chief
absolutely.
Justice of this court would be required to come file petition and then have the benefits of his
My
retirement.
lord, then today I am handicapped because day before yesterday I engaged in this case, my lord.
That's
Earlier,
right,
some
but-
other
but,
counsel is- So let
don't-
me, only 1 week time only, my lord.
I will give you time, but on the next date, you must be prepared on
My
all
lord.
aspects of the
My lord,
Mr. Gyani, we are giving them 2 weeks to let us know. We will not brook of any lax approach in this matter. Either it is by the High Court or the Accountant General or the government. We'll see whatever is due to you shall be paid to you.
May I submit even for that 20% which ought to have been paid in July 2015, that was paid and is still being, paid. I have filed those documents, 223 years for them. The
Yeah.
judgment, and in the meanwhile, they never bothered. Less said the better about.
But Mr. Gyani, can I request you, once you have been paid that amount, to please spare them? Perhaps not because of any willful negligence or deliberate disobedience. There was some problem somewhere. Now that you have been paid, we would ensure that all your
Yes.
entitlements shall be paid to you.
my lord.
So
All
far,
right.
they have not paid me. From 1/1/2016, that is the statutory provision to which they have not shown. I am asking, my pension slips are there on record, even the
You please have the records for each of the years, because
Yeah, it is there. It
All
has
right.
already been submitted. And so
All right.
far, so in
from
30
30/7/2015 to 31/7/2020, every year's computed amount, whether it has been paid.
My lord.
And then with 30% further increase,
I have-
31/7/2020.
And for
And
that,
we have not examined the rules. The rules would talk of 40% for his 90th year. So just find it out,
My
tell
lord.
us. We are giving you 3 weeks.
My lord, deeply okay.
Don't delay any further.
My lord, definitely.
And if you are putting an affidavit, give a copy in advance to Mr. Gyani. Have it reached to his house.
My lord.
Sir, you stay in Guwahati only, no?
No, he's
no, I am sitting at Indore. I was
Indore.
not
Sitting
allowed.
at
I
Indore.
would have been happy to
All right.
make my appearance in person, but none of my family members permit me now to travel.
No,
Now,
that's
and
right. We would
you are-
also have we as your judicial family would have also dissuaded you from coming to Guwahati during these rainy days. So you do one thing, we will have the affidavit, copy of the affidavit served upon you. It will be either sent to you through mail or it will be sent to you through post.
My lord.
Don't worry about it. We will have every entitlement of yours paid as early as possible.
I'm grateful, my lord.
All right, Mr. Chair. Take down.
Given my written argument and said when the matter was being, I mean, the orders of this honorable court, they are beacons for me in recent past, 24, 25. And
Yes.
then I thought,
All
in
right,
a-
all right.
even before conclusion, 2 months that I'm inching towards 90th. That
Honorable-
already is on record with documents that written.
All right, sir. All right, sir. We'll on the next date we'll inform you. If you so require, if your grievance still continues, we will see what is to be done. Take down.
Not as if I had not come to attend this case, but
Honorable Mr. Justice.
senior lawyer, just kindly just one word,
Yes.
who opposed me in my appearance as a lawyer, since he was appearing as an advocate general opposing habeas corpus, but he was my senior advocate. And when I expressed to him that I have heard you many times as a judge sitting on the bench, now let me sit beside you, and he dissuaded me. No, it will create a bad impression. You did not come. 3-4 times I did come. But then I did deliberately, not even entering the High Court precincts, visiting the bar, nothing. Otherwise I could have shared
Honorable Mr. Justice
Yes.
Virendra Dutt Gyani, former acting Chief Justice of Guwahati High Court, has appeared in person virtually, in this matter. He is seeking additional pensionary benefits under Section 17, Capital B of the High Court Judges Salaries and Conditions of Service Act 1954, which entitles him to be paid an enhanced pension slab of 20% from the first day he enters his 80th year, which in the case of the petitioner is 30/7/2015, and an advanced pension slab of 30% on the first day of his 85th year, which falls on 31/7/2020. The contention of the petitioner is that he would now be entitled for an enhancement of 40% slab on the pension for his having attained 90 years of age.
No, on stepping, I'm running 90. And this honorable court judgment and that of the Supreme Court upholding it, that on the first day, on commencement, the language is
He would be entering in the 90th year.
stepping into the 90th year. Has already stepped, it is now 30th of July.
Based on the communication made by the Registrar General, Mr. Mahanta, learned standing counsel for the High Court, has submitted that payments have been made, but details have not been supplied to him to be communicated to us. Let an appropriate affidavit on behalf of the High Court be filed by the next date. Re-notify on, give a date after 3 weeks.
My lord, can you make one submission? Annexure C has been filed by the respondent number 5, the pension processing cell, which says their case hinges on the entries, 2 entries made, that basic pension of from 1,12,500 commencing from 1/1/2016 to October 2018 for 34
All right,
months.
sir. We will see all of this on the next date.
22nd September.
Deeply.
Item number 2.
I am grateful to this honorable court for taking before I may not be having another opportunity, God forbid.
No. You shall have. Let's see. Yes. Next.
Item 2.
Service not complete, Lordship.
What happened?
Service not complete, Lordship.
What does he say?
We may be allowed to take press steps, Lordship.
Awaiting the service of notice on response number 1 and 2, the matter is adjourned to.
You want to take fresh steps?
You want to take fresh steps?
Lordship.
Has the
From last 2 occasions that is everything.
no. Let us wait for one more thing.
Lordship.
Awaiting the service report in respect of notices issued to respond number 1 and 2, the matter is adjourned to so and so date.
19/9. Item number 3.
This is for delay for the next 260 weeks.
Yes,
My lord, I'm seeking an accommodation on behalf of my senior counsel, D. Gover. My lord, he's under bereavement. Otherwise, my lord, delay confirmation.
Delay confirmation matter, lordship, I have already filed my objection, your lordship may consider the main appeal.
we are inclined to condone the delay.
Lordship,
The present application is for condoning the delay of 266 days in preferring the appeal. For the reasons stated, we have heard the counsel for the appellant applicant as also the respondent. Good grounds have been made out in the application for condoning the delay. For the aforementioned reason, for the aforesaid reason, we condone the delay and allow this application. The delay stands condoned. The registry would process the listing of the process the filing and listing of the appeal. Deeply of the exception. Yes.
Item number 4.
May it please, Lord.
Yes,
This is the appeal preferred by the state, my lord.
2000 days.
Yes, my lord.
What is the reason?
My lord, paragraph 5 to 12, my lord.
Let's see paragraph 5. No, these are no good grounds. These are no good grounds. No. The application is rejected.
Much obliged, Lord.
For admission, item 6.
My lord, basically, the government was directed to obtain instruction as to why that subsequent,
That's all right, but we have gone through the judgment
yes,
of Tej Prakash.
yes,
You're right there that Manjushri has been held to be a good law.
yes,
Good law for the reason of the logic employed,
yes,
but not for what was done.
yes. No, my lord, if your lordship would kindly come to the very first paragraph of Tej Prakash, very first paragraph.
Yes,
What was the terms of reference? That itself answers the query, my lord.
no, that's true.
The very first paragraph,
Yes.
a three-judge bench of this court, while accepting the salutary principle that once recruitment process commences and the state or its instrumentality cannot tinker with the rules of the game, insofar as prescription of eligibility criteria is concerned, wondered whether that should apply also to the procedure for selection.
So therefore, since this process of computing marks on the basis of post-graduation degree was delineated in the advertisement,
Yes.
therefore any tinkering with that would amount to change, not necessarily rule of game, but not permissible, because there does not appear to be any rational nexus.
No,
I mean, there appears to be a nexus
No,
because it
there-
is not.
Milord,
going to-
Milord, we have filed an additional affidavit record on the If your lordship would kindly have the additional affidavit. Now, Milord, I have not heard anybody getting 90% in English
No, he is
literature.
there. The person
No,
is
Milord,
there.
how he got it, that's what we have brought on record.
No,
That matter
he-
is being investigated. Kindly see, Milord.
Mr. Chaudhary, we are not called upon to decide that.
No, I'm just, no, I know.
We have not been called upon to decide that. It will be extraneous
Yes,
to the consideration of this appeal.
Correct.
We quite understand.
yes.
But then let it remain, you get the same marks. You get only 3 marks less.
No, my lord, there is an aspect. What had happened, he initially secured 60 odd marks
No, we
from
will
a
not-
particular
we-
university.
Mr. Chaudhary, you understand?
Anyway,
You,
Lordship said Lordship will not go to that area.
because we are under no obligation to get into that.
Right.
And we believe that we must not exceed the mandate.
No, but-
You will always agree that if a
Yes.
judge does not know his limitation, the boundary within which he has to operate, you would not be happy
True,
in
true.
some other situation.
No.
But then how he obtained 90 marks is not for us to decide.
Yes, yes.
The question is that whether this would amount to change in the rule of the game.
Yes, that is
Now,
the issue.
we would have said no. Prima facie no, because it is only with respect to the processual part of allotting marks.
Evaluation process.
That's right. Evaluation process, marks, particular number of marks for particular slab of
Yes.
percentage.
Yes.
Now that also, after having been stated in detail, suppose interview would not have stated, the advertisement would not have stated all that. Absolutely clear. It would not have applied. This was permissible. But now once it was made, there was no necessity.
No, my lord, then my lord, my second limb of argument in that case would be in view of the latest judgment of the Supreme Court, my lord, where Rangaya was overruled.
Where?
There, Rangaya, my lord, Rangaya's decision that,
No, you talk about this
no, my lord, there is another line on this, my lord.
Tej Pratap.
No, Tej Prakash is one line.
Yes.
The other judgment which I am relying is, my lord. কিতাপখন কি হ'ল কালি মই যে জাজমেন্ট নহয় নহয় কালি যে পিছত জাজমেন্টটো চাইছিলো ৰাজীৱ কিবাটো
We would not have bothered for this.
no my lord
Only for the reason of this
One
judgment
second.
it says.
কালি যে মই পিছত জাজমেন্টটো উলিয়ালো সেইটো ক'ত ঠিক আছে এই যে মই যে মানে সেইটো কি সেইটো
Anyway, tomorrow,
no my lord there is one judgment of the recent judgment of the Supreme Court my
what
lord
does it say?
their issue was
Are you
the-
referring to Tamil Nadu Medical Officers?
no my lord
Association?
that one Rajiv something recent judgment my lord हाँ राजीव शर्मा ना हाँ हाँ हाँ
Where is that? You have a copy? Give the citation. We'll have the copy. We'll hear you tomorrow.
yes my lord
Tomorrow.
yes yes
All right, Mr. Chaudhary?
yes
Now, if this was not provided in the advertisement, we would have gone straight away. The recruiting agency could have changed that.
no my lord
No
my
difficult.
my only endeavor would be to persuade your lordships to take the view that some distinction has to be called out between condition of eligibility and other requirements.
Is there any dispute, Mr. Chaudhary? We do not have any dispute in our mind. We have no confusion in our mind. This does not tinker with the eligibility criteria.
Yes.
If it were, then perhaps we would not have allowed you
No, my lord,
to argue.
the reference is test procurement was only to that extent.
To that extent, yes, that is what we are saying.
That's why
Just a minute, Mr. Chaudhary.
that's why that proposition D, my lord.
Proposition D, I have read it
Only
twice.
one rider that it should not be arbitrary.
Mr. Chaudhary, I have read that proposition number 4 in the context of what you argued on the last day twice. Now, this is in the context of, now you have to see Manjushri, you have to see Marwa, and you have to see this Tej Pratap.
Yes.
Now, therefore, this does not tinker with the eligibility criteria in no way. It is only with respect to marking. That also for post-graduation.
Yes.
So this could have been done, absolutely no difficulty. They could have said 70% onwards, 30 marks. Or 80% onwards, 30 marks. They could have done that internal arrangement, or they could have made it known to the authority, to the applicants. But once it was decided, then would it be, it would not be
No, my lord, the
justified.
date was notified earlier.
And apart from that,
No, that was notified
this
was
notification also
Ah.
comes later. It says that it shall be effective from that date. Now, testing it from both angles, we are finding it difficult.
and my lord, the other judgment says
Let's see
the
that.
proposition in Rangaya, what was said by the Honorable Supreme Court was, my lord, that whatever the procedure laid down on the date of advertisement, that will govern this election. Supposing there is an amendment of the rules in between or the prescription.
I had the occasion to go through it. Is it by Justice Narsimha?
Yes.
I have read that.
2023, my lord, 2023 3 SCC 773. State of Himachal Pradesh versus Rajkumar.
Right.
2023 3 SCC 773.
Which paragraph would you like?
Yes, my lord will kindly come to paragraph number 82, my lord. Page 817.
Yes.
A review of the 15 cases that have distinguished Rangaya would demonstrate that this court has been consistently carving out exception to the broad proposition formulated in Rangaya. The findings in these judgments that have direct bearing on the proposition formulated by Rangaya are as under. There is no rule of universal application that vacancies must be necessarily filled up on the basis of the law which existed on the date when they were arose. Rangaya must be understood in the context of the rules involved therein. It is now settled proposition of law that a candidate has a right to be considered in the light of the existing rules, which implies rule in force as on the date of consideration takes place. The right to be considered for promotion occurs on the date of consideration of the eligible candidates. The government is entitled to take a conscious policy decision not to fill up vacancies arising prior to the amendment of the rules. The employee does not acquire any vested right to being considered for promotion in accordance with the repeal rules in view of the policy decision taken by the government. There is no obligation for the government to make appointment as per the old rules in the event of restructuring the cadre is intended for efficient working of the unit.
This for filling up.
The only requirement is that policy decision of the government must be fair and reasonable and must be justified on the touchstone of Article 14. So my respectful submission is, my lord,
would not be relevant because this is the
in
same.
the context of promotion.
This is promotion, not only promotion, this is also appointment to vacant seats.
Yes.
If they
When,
decide,
whether the rule obtaining on the date of when the vacancy arose would be applied.
that's right.
Or on
They say it will not. If it does not tinker with the eligibility criteria, then perhaps
my
it
lord,
will not.
all that I was trying to submit for lots of kind consideration is paragraph 82.3, the last sentence, my lord, which is similar to the prescription or the answer on the question D, my lord, where it says that authority has the power provided it is not arbitrary, provided it can withstand
But
the
why,
test of Article 14.
why do that for no good purpose? I mean, why at all? That is the question. Now, if you see.
No, Lordship also wanted to know what was the state's perspective in bringing this new notification.
Yes.
That is how the matter was
Yes,
adjourned.
you have to say.
Partial modification was done as per the honorable court's order. In one of the petition, honorable courts direct us to.
Have you followed what we really want you to tell us? Now, what was the reason for doing so?
Reason
There, you see, somebody can smell rat. Because as it is, you have given good percentage of marks for anybody above 90. So you have reduced it to 87 or 85. I mean, that slab is something different. But why? Why exactly to do that?
That was done as per the honorable court's direction. That was one of the petition honorable court directed us.
Where is that? Where is that?
Yes, because the difference of marks between the old entry and the new pass out, there is a total difference. So my lord may kindly come to paragraph 32 and 33.
Paragraph?
32 and 33. Internal page 22. Last page is last one page. Second last page.
So therefore a larger range.
And that was also lordship put to select before the honorable division bench.
Three?
My lord.
Because this had never struck me. I'm surprised at the ingenuity of the honorable judge who has given this reasoning. Look at paragraph 31. Look at paragraph 31. Forget about the facts of your case, whether you win or succeed.
Yes.
Look at this reasoning.
However, we take note of another aspect of the matter, that the real concern of the petitioners are that some of them have acquired their qualification about 10-15 years back and have demonstrated certain metrics on record to show that the strictness of the mark in qualifying examination that prevailed about 10 to 15 years back was much more stricter than what was in the later years.
And otherwise
view of-
also the principle is
In
this.
view of the differences in marking method that prevailed, the petitioners claim that they have formed a class with a reasonable classification from all such other candidates who acquired their qualification at a later period. In view of such very 72% weightage.
No, that is something else. That's the logic that there has, I mean, with respect to the marking given to persons, there is great variation. So in order to nullify that variation,
Or to rationalize it.
a bigger slab is given. That's the reason.
That is the reason. And that was also put to seventh record on
Very good.
division
So
bench.
you have been able to find out this and tell us the reason. This had never struck us. This would not have struck us otherwise.
Lots.
Now, Mr. Chaudhary must admit that this is the clincher today.
Yes.
And otherwise, that was also appealed by the honorable division bench. also.
And you were only insisting for the reason. By the state. Good.
And that was upheld in WA number 302 of 2022 lawsuit. That I told you, 302 of 2022.
इसको division bench में So, Mr. Chaudhary, if you are sorry, we dismiss it. Appear in the examination, steal a march over Mr. H.R.A. Chaudhary by getting more marks in your.
My learned friend's client initially secured 62.5.
That is another.
Then he took another degree
No,
from
that-
another
that
university,
we-
90.5 in English literature.
No,
It was mathematics.
Therefore, Mr. Chaudhary, no, don't you see the marking of today? People get 100%. You know, the cutoff, just for your information, last year, the cutoff for St. Stephen's College for history was 100.
Yes.
Now, do you expect 100 marks to be given to a candidate? But in that case, you'll have some opportunity of, hounding him later.
Yes.
But we can't decide it here. All right, yes. We appeal dismissed.
Item 7.
May I present your lordship?
Give your appearance slip to the State Council.
My lord, before my learned friend starts, my lord,
Yes.
actually, by the impugned judgment, my lord, I think 3 writ petitions were, as many as 9 writ petitions were there. But they have preferred this appeal only in 1. So, my lord, since it will cover the other cases also, if 1 copy is served upon us, then let the matter come up on Monday, my lord, will address, or Friday, my lord, will address your lordships.
Oh, these are employees, these are.
Yes, my lord. In fact, I argued this matter before the learned single judge.
All right, contractual employees.
Yes.
My lord.
Normally, it is not required to notice them if their term of contract is
Yes.
over.
Yes, my lord.
But the moment you terminate them, stick with the stigma.
Yes.
If you keep it, then
Right.
perhaps.
And
it
that is what
required.
learned single judges held, my lord. On the expiry of the term, if somebody is released, that's a different thing. Here, my lord,
And then you have been given an option.
yes.
Don't renew.
Hmm.
Don't renew,
lord.
reinstate them in service, don't renew, ask them to go. They
There-
can't do anything.
Yes, my lord. In this case, there are 2
I
issues, my
think you
lord.
should have done that instead of challenging it in appeal.
My lord, there are pending cases, my lord.
No, it's a specific related contract is what and in single case, they have been taken note of and take that difference for this.
I think so.
My lord, I'll satisfy whether this is stigmatic or simplicity, my lord.
Completely satisfied. The idea that they were made accused in a criminal case, this was at the back of the head.
My lord, that is only the motive, my lord, not the foundation of the termination order, my lord. I'll satisfy, my lord.
Anyway, all 3 matters together.
Yes.
My lord, 9.
Have they been reinstated or not?
My lord.
No.
What are you doing?
Yes.
You have an option. You could have asked them, you could have come out with an order reinstating them and then allow their period to expire. Then show them the door.
Lordship may fix it on Monday. I'll try to satisfy, my lord.
Why are you wasting your exercise?
Because.
I mean,
number
there
of
has to
cases-
be some rationale behind. I mean, do you have a litigation policy in the state of Assam?
My lord, may I submit one thing, my lord?
Just a minute.
My lord.
When I'm saying something,
There is
try and
none.
understand.
There is none.
Nothing, my lord.
Every state
No.
these days, they have come up with, a litigation policy for that state. you should act in such a manner that there is no multiplicity of proceedings and useless, burdening of the court with such petitions. You have been given that thing, that advantage in the judgment. Even though you lost it there,
My lord, in a similar case, my lord, in a similar situation, another case was dismissed, my lord, and petitioner preferred writ appeal, which is still pending, my lord. And thereafter, this case has come, my lord.
Para
This case has
19.
come.
other cases will be decided other time. You
I'll satisfy him on Monday, my lord. I'll try to satisfy him.
Para 19 Mulam.
On two cases.
Narsima.
Anyway, Monday or tomorrow?
Friday, Miller.
Friday. Monday is holiday, my lord.
Monday holiday.
Let it be on Monday. And all three cases, do you have the number?
No, my lord, not yet filed. Other cases not yet filed, my lord.
Then we'll decide it. Abhi aap
Yes.
can you argue it now?
On these cases also, my lord.
Can you argue it now?
My lord, I can argue, my lord.
Yes, yes.
Let's finish.
My lord, I have submitted one list of citations, my lord. I just want to read these judgments, my lord. The relevant paragraph I have quoted, my lord. May I read one by one, my lord? First case I am referring, my lord, this is Rajasthan SRTC versus Paramjit Singh, 1919 6 SCC 250. There in paragraph 2, clause 16 of the agreement stipulated that the first party will have the right to terminate the temporary appointment of the second party at any time without any notice. Lordship is satisfied in this case because this point was that we can terminate the contractual employee. I am not reading this. Lordship may kindly come to the second one, my lord. The State of Punjab versus Balbir Singh, 2004-11 SCC 743. Thus, the order of discharge simpliciter prima facie is not punitive, it being in terms of so and so rules, but the question still whether the incident which led to the passing of the order was motive or including factor of was foundation of the order of discharge. Paragraph 6, the test of determine whether the misconduct is motive or the foundation of an order of discharge was laid down after exhaustively dealing with the case laws on the topic in the case of Radhesham Gupta versus UP State Agro Industries Corporation. Number 33, it will be noticed from the above decisions that the termination of the services of a temporary servant or one on probation on the basis of adverse entries or on the basis of an assessment.
The argument that you can make is this.
Motive and the foundation.
No. The clause which says that if this can be done if the employee is an embarrassment.
My lord.
That is the only ground that you can take, and therefore this is an embarrassment for you that one of your employees was made accused in a criminal case. That's
the
all.
arrest of the case in the misconduct in the department, my lord. My lord.
This is just another view. If I were the single judge, I would have dismissed the writ petition. But now, since it has been decided by a single judge, we would not like it to be tinkered on a very slender ground. That's the reason.
Just before passing these judgments, my lord, another single judge, my lord, had passed, my lord. Lordship may kindly see. I've quoted, my lord, the Jan Saikia case.
The judgment says so.
Yes, my lord.
Normally, we will
Judgment is also referring.
specify it in the judgment. Because you should have not said anything. Without saying anything, if not embarrassment, nothing, the term is over, let him go.
My lord, it will increase the stigmatic, my lord. It will become stigmatic if we will mention anything about the merit of the case. My humble submission is that
This is not your disadvantage. Who stops you from not continuing him in
my lord,
service?
that may be reflected, my lord.
We'll
I'll
see.
grateful. I'll grateful.
6 months.
I'll grateful, my lord.
We will do only that.
That we are liberty, my lord, not to continue with them, my lord.
Do you require us to say that?
My lord, because reinstatement order is there.
Reinstatement, you reinstate,
Because
continue till the period of the contract, show him the door. Say that no.
There, my second argument is, then, my lord.
Mr. Counsel, I would not remember your name now. but
S. Dot.
Reserve your energy for some other case.
My lord.
You apply your mind like this. This is nothing. These are casual employees, temporary employees. You get them into service, go ask them to go again.
That-
They will. They
That
are
may be
good people.
reflected, my lord. My lord, I am
We,
just
we,
saying,
we exceeding our. Why do we do that?
my
Why
lord,
do we do that? It's a contractual obligation. That's what.
because
Anyway.
fact is that the contracts are over in years back, my lord.
Appeal dismissed.
My lord. That may be observed, my lord. I'm humbly praying, my lord. Obliged.
दोनों मेरे पास रखना अभी लिखा
Item 8.
Made My lord, on two grounds, we are sealing this order of the learned Central Administrative Tribunal, my lord. Firstly, my lord,
What has happened? Tell us what has happened.
no, inquiry report was not before the tribunal. Nobody knows what the inquiry report contains. Number one.
Let us see the order of the cat.
Yes, my lord. It is at page 149. It starts. My lord may kindly come to page 155. Para 8-9. Heard the parties, peruse the records and consider the submissions of the rival parties. After considering the facts of the case, perusal of the records and submission of the rival parties, it seems that there were some irregularities occurred in the selection BOO and the selection procedure was not in accordance with the SOP for filling up Gupsri civilian post. Moreover, no right of the petitioner has accrued while only participating in the recruitment process. Thousands of people appear in the recruitment process and every person would not be selected until and unless a person is not selected and joint service, employee and employer relation does not come into existence. No right is accrued in favor of the candidate. Here the applicant who simply participates in selection process has no locus standi because it is a sort of a public interest litigation which is not maintainable. Lord, the learned tribunal failed to realize the distinction between recruitment and appointment. Supreme Court has clearly spelled out the difference, my lord. As far as the selection is concerned, this is a right flowing from Article 14 and 16, and everybody has a right of due consideration. Mahendran's case, Supreme Court said, my lord, whenever a person applies pursuant to an advertisement, he has a right of consideration. And what is this locus standi business, my lord, that I have no locus standi?
No, that's
And secondly, my lord,
they are ignoring that concept.
my lord, secondly, the inquiry only recommended, but in the written statement, they said it was directed. And most importantly, my lord, what is the content of the inquiry report? They relied upon some materials which is after the date of interview.
The interview not really.
And the my lord, selection procedure does not envisage interview component. The allegations were that some bribes were demanded for the interview, whereas there is no interview component in the selection process. Recommendation to 90.
So that's right. This fraud and everything vitiates the entire process. So your
No, my lord.
legitimate expectation has gone down. Definitely, you were successful in all respects.
No, my lord,
But
my
instead
only.
of pinpointing, they have cancelled
No,
the
my lord,
losses.
no, my lord, my humble submission is.
Do they have the authority to do it or not?
Yes, do it. They have.
Yes.
They have. Why not? In an appropriate case, yes.
Yes.
Because my right of considerations can be denied. If one can, but where is the inquiry report? Now, I'll just show two things, my lord.
That question, that can it be questioned?
Yes, because if your lordship would kindly come to
Now,
page number.
do we go into the sufficiency of the reason?
No, no, my lord, it's not a question of, please come to page 94 for a moment, my lord.
94.
Yes. Para 3. In view of the available clearly indicated evidence regarding procedural violations with respect to the BOO, it is recommended that completed so-and-so proceeding be quashed. Now, my lord will kindly come to the written statement filed by the authority, my lord, at page number 81. Page 81, first para. The present OA pertains to cancellation of selection process of 18 vacant posts of housekeeping staff, painter, Aya, etc. at 5 Air Force Hospital, Jorhat. The said vacancies were released in employment news dated so-and-so. Applicants being eligible participated in the selection process conducted at 5 Air Force Hospital, Jorhat. After conduct of written and trade tests in accordance with the laid down procedure, candidates who made in the merit list were called for further course of action to civilian. So this is the stand. Then my lord will kindly come to page number 84, my lord, para 12. Direction to what place? Para 12, my lord, that with regard to the statements made in para 5 of the original application, the respondent begs to state that selection procedure was not in accordance with the SOP as brought out in the investigation report. Accordingly, headquarter white letter dated so-and-so directed, never directed, my lord. So they have understood the recommendation to be mandatory. Number one. Secondly, my lord, what are the allegations? Kindly see.
Chaudhary, that is unhappy drafting.
No, my lord, my humble submission is, my lord, let the inquiry report be placed before your lordships. If your lordship records a satisfaction, then I have got nothing to say.
Therefore, I asked you a question.
Yes.
Now, do we really go into the sufficiency of the reason? Especially when the government has taken or the recruiting body has taken a
No, my lord,
decision that it is invested with
why?
fraud.
Yes, normally no.
Your claim is only based on legitimate expectation because you have participated in the process.
And I was selected.
And you have been selected you have been kept in the wait list.
Yes.
All the judgments that you referred in the earlier case.
Yes.
That also relates to this only. Manjushri. What does Manjushri say? Marwa say that you were selected does not give you an indefeasible right against the state or the recruiting body that you shall be appointed. So either they decide not to fill up the post or they decide to quash the entire proceedings.
No,
right. So therefore, if there is any illegality, we will question immediately. We will put our check.
Milo, with great respect, I'll try to like to call out the distinction, Milord. When it comes to right to appointment, yes. But when it comes to, Milord, tinker with the recruitment process.
No, there's no
No. What I'm saying is, Milord, what I'm trying to submit for lordship's kind consideration. Yes. Supposing, Milord, I'm selected. Authority decides not to fill up the post. I have no right. To that extent, RS Das is very clear. But, my lord, what I am saying is, in Mahendran's case, Supreme Court said, my lord, when a post is advertised and somebody participates, then he has a right of consideration. That right of consideration can be denied on a very good ground. Now, that there were irregularities, then that lordship must be satisfied about that. I'll show, my lord, that there is nothing. Because the complaint is dated after the interview. And there was no interview. The allegation was there was some payment of bribe at the interview, whereas 104 page, my lord, the selection procedure does not envisage interview.
Therefore, Mr. Chaudhary, you would agree with us.
Yes.
That if that were the ground of attack,
yes,
then perhaps the person concerned or somebody else would not have gone to CAT. This was a matter to be decided under Article 226, whether these were good grounds for cancellation of the entire process.
No, since it is a matter relating to recruitment.
You went to CAT for the reason that it pertained to service. All conditions of service, therefore CAT is available. This question could not have been gone into by the CAT. And this is a writ petition, basically in appeal.
My lord, that
Challenging
is,
it. See, try and understand this.
Uh,
All the reasons. all
L.
the
L. Chandrakumar says, my lord, the primary approach has to be before the cat. L. Chandrakumar, para 99.
That we are not questioning that. We are on a different aspect altogether. Look at this. Now, that there were no sufficient grounds for the recruiting body to cancel the entire process. Whether this has been deliberated upon by the CAT.
No.
Could CAT deliberate upon it?
In any case, now the matter is before.
Now the
Lordships.
matter is before us. So therefore, this is not a question. I mean, if you want us to.
No,
have it
my
on
only
record, we'll do
submission
it.
is, my lord,
But
let them produce the, Lordship need not even issue notice. Let them produce the, my lord, records of the inquiry report, which was never before the CAT, my lord. If going through that, if your Lordship is convinced,
Suppose
I'll not even make any argument.
the inquiry report is lopsided.
Then
I'm just putting a question to myself. Suppose the inquiry report is lopsided, the evidence are not strong enough, not clinching enough for the recruiting body to decide that all of it should be thrown out and fresh process should be. Then where do we have the jurisdiction to tinker with that decision? It's their process, it's their thing. The moment you acquire a right, if that is diluted to even the minimum level, we enter the fray.
No, my lord, subject to what your Lordship may say, my lord, my right arises because the refusal to go ahead with the
Now,
selection
just-
process is actuated by reason which is not inspiring.
Test it from different angle. Now
Yes.
forget about service. Here you have not attained any right. You have attained a right to be considered.
Consider it.
That right you had when you were a participant.
Hmm.
That right you had when you filled in the forms against the advertisement. That right continues. And the continuity will be all through. But question is that you don't have an indivisible right of your being appointed, of your asking
yes.
the state. That is there. Now look at this. Many a times tenders are floated. Everything is in process. The government takes a call that, well, it was not in the particular mode, the new mode in which the tender should have been said. Let's cancel it.
Yes.
Why get into litigation? Now here it's a question where there was an allegation of somebody accepting 5 lakhs rupees, and even the names of such applicants were made known to the authorities. They saw, in fact, the whole thing would have been vitiated, no?
No, my lord,
And there would have been many FIRs.
no, my lord, my only
And
concern is,
maybe you don't know. Maybe you don't know. You would have been caught in the dragnet.
no, my lord, my
Whereas
only
you're
anxiety is, here the entire allegation is regarding interview component. There is no interview component. Kindly come to 104, my lord.
Suppose it were not there. Suppose,
Selection, no,
just a minute. Suppose the allegation of bribe taking by the officer was not there.
no, my lord, the allegation is that something went wrong in the interview part. No, there was no interview component. I am on that.
Interview, not in the interview.
Page 104, my lord.
That's wrong.
There shall be no interview in the selection of candidates. Page 104.
We are not concerned with that. Look at this.
Now please come to the allegations, page 89. These are the complaints, my lord. We have a next. Page 89 and 90. Kindly investigate requirement of 5 Air Force Hospital, Jorhat. Why hospital authorities conducting the interview in very short period? Whether candidate was not getting call letter on time before interview, there is too much bribery is going on. Kindly investigate. No interview, my lord. Then page 90. In 5 Air Force Hospital, a fraud requirement is going to be held on 29/8/21. So-and-so began, so-and-so are going to get job. One Sunil Vicky and Chanda Kaswa in bribe examination candidate have got call letter. How the candidate will come out from Assam, they may not get call letter after interview out of so-and-so, so-and-so, so-and-so. Well, there is no interview. It is only written test and skill test.
No,
That's why I'm saying, my lord, that inquiry report should have been before the honorable tribunal. We tried to impress upon the tribunal.
Come to page 82.
Yes.
That the investigation part, what is the communication, that's a mistake.
Yes.
Come to page 82.
Yes, my lord.
And, come to
On
last-
receipt of complaint.
Yes.
My lord, before that, I'll just show one page, my lord. Please
Now,
come to
first read
page.
this. First read this.
Okay, okay. Based on the
The
aforesaid
last two lines,
complaint.
the major ones related to the scrutiny of applications,
Yes, my lord.
dispatch of call letters, preparation of question papers, allotment of roll numbers and checking of answer sheets. That's all. And
Page.
then
They don't receive also so and so, so and so, so and so.
thereafter,
Major ones related to scrutiny of application, dispatch of preparation of sir. Considering the material irregularities
and
in
then,
the selection, BO, it was decided to.
and then page 83, paragraph 9.
That with regard to the statement in so and so to state BO was caused based on I'm on that. That investigation report was not before the court.
It need not be, no. It need not be. We are only, this is only for the purposes of general satisfaction that there was a reason. It was not without any reason. So therefore, your rights have not been extinguished forever.
Milord, in Indrapit Kehlon's case, in spite of
You
everything.
remember, Mr. Chaudhary, you remember so many cases, I don't remember even one. But the principle is very clear that, when you don't have a right, when you don't have an indefeasible right, the right is with the government not to give effect to this recruitment process and carry out afresh. And it is not very, very unreasonable in the sense that there was a complaint. Can we question the sufficiency? Can we question the grounds? Can we lift the veil and see that the investigation was not correct? Now, would we not exceeding the boundary?
No, my lord, all that I was trying to submit was, I think lordships should look into that inquiry report, my lord. If inquiry report reveals something, yes, I'll not even make an argument. Only thing is, my lord, in the
Suppose on the complaint only. Just a minute, Mr. Chaudhary,
Yes.
a hypothetical question to you. On the basis of a complaint received by the superior authority in the army,
yes,
that there is large scale bungling and there is a possibility of demand giving an acceptance of bribe money.
now
For the
supposing that
No inquiry, nothing.
okay, I'll answer it. Please
Haven't
come
we
to
done it?
please
We have
come
done
to
it in the past.
please come to page 92 for this answering this, I mean, lordship's query, my lord. Kindly see, this is a complaint dated 28/10/21. Am I clear, my lord?
Yes.
Handwritten,
Yes.
type copy is in 93. But please come down below when it was received, 27/10. These are the nature of allegations, my lord. That's why we say the complaint was filed on 28/10 and it was received on 27/10. These were the materials. And this was the basis for the, and para 10 of the written
1
state.
second, sir.
Yes.
1 second.
And kindly see, my lord.
1 second.
The-
1 second. One of the complainants
Yes,
is you.
yes, yes. Even I file FIR also. And this is not my signature, somebody else. That's why I said, my lord, 28/10 they
Why
filed.
you get into all this?
No, my lord. 28/10 they filed the complaint and it is received on 27.
Perhaps that was the time when you did not know that you would be successful.
No, my lord, it's not like that. No, Lord, we have undergone, in the very first paragraph of the written statement, they say everything was done in accordance with
We are
SOP.
only on the authority and the power of the recruiting body.
All that I was, if, my lord, there are no materials. If there are no materials, then certainly, my lord, it will be a case of an arbitrary exercise of power. Now, if the materials on record satisfies your lordship's concerns, then perhaps, my lord, I leave it to lordship's, my lord, but I had a feeling, or rather I would submit, my lord, that if inquiry report would have been before the tribunal, perhaps, my lord, things would.
We are not getting persuaded to even look into the inquiry report. That that is the reason. You have placed your case at the highest. We understand that. You have placed it at the highest. But then we are not getting persuaded for our own reasons. The law which has been laid down by the Supreme Court and by us in most of the
I think,
cases.
my lord, so far,
Otherwise, there is no end.
regarding appointment, absolutely, there is no doubt, my lord. Even if I am selected, authority may not appoint me. To that extent, there is no difficulty.
Right.
But Supreme Court has carved out the distinction regarding recruitment.
It has. Not only recruitment, in any aspect. They say that the decision is absolutely based on nothing. But in this case, if there is an allegation, there is some kind of preliminary inquiry and it is found, it would not have been safe for the recruiting body to have continued with it. This is the problem which we have we have witnessed as, high court administrators in my state. Now, if there is one complaint and that complaint has some semblance of truth, we cancel the entire thing. Because otherwise, who is going to face litigation in courts of law, in judicial side, accusing the entire high court administration? Why do it? Let me cancel. In fact, that is the reason, Mr. Chaudhary, we would tell you that I was one of the strongest dissenters on this. The High Court administration always would like to have the recruitment thing left to themselves, that they decide. Because there is every likelihood that it will be done in the best possible way. But you never know where would be that loophole, where would be that question leak, which person might play truant. And in that case, you become defamed. So I whenever I was to decide, I have decided that it should be done, it should be outsourced. So that the High Court can always call the person and say that any complaint we will lodge FIR, will take you into custody. You can't do it yourself. This is the reason. Now, therefore, we are absolutely satisfied. We have heard Sri. But I must tell you, Mr. Chaudhary, you made us think a number of times.
But my lord, the person against whom the allegation was that he took bribe, he has been promoted. And honorarily, he has been allowed to go on retirement.
Where did you get this information?
Yes. Page 130.
Anyway,
No, my lord, I'm not joining issues.
and all these are part of your record.
Yes.
Yes. Yes, page 130. I thought I will not place this. Page 130, my lord. Somewhere in the middle, the said allegation is entirely incorrect. As the applicant number 3, 4, and 5 had received their admit card through post, which will be evident from the records pertaining to the selection process in question. Even assuming but not admitting that Amit Kumar Srivastava had taken bribe as alleged in the said complaint, in that event, it was open for the competent authorities in the Indian Air Force to take disciplinary action against the said official as per rule. However, the applicant came to learn that after filing of the said complaint, said Srivastava was promoted to a higher post. It is further learned that at present, Amit Kumar Srivastava has retired from service and has been provided with all retirement benefit attached to the promotional post. Actually, my lord, sometimes when people do not get job, they do create, my lord, an impression as if something is amiss. Because here in this case, my lord, the allegation was regarding interview. There was no interview component. The person who is, but my lord, this person should have been dismissed because their discipline is much stricter than the civilians. He should be court-martialed.
We have heard Sri Ken Chaudhary, learned senior advocate for the petitioners. How many of them? For the petitioners. And
Four of them. Four of them.
Gayan. And I must say Gayan for the respondents. The petitioners had applied for recruitment to the post of 2 housekeeping staff and 1 mess staff at the Air Force Hospital, Jorhat, pursuant to an advertisement dated 3/4/2021, issued by the respondents. The recruitment process was conducted in terms of the standard operating procedure for filling up Group C civilian vacancies by direct recruitment. The contention of the petitioners is that they successfully cleared both the written test as also the trade proficiency test. Whereafter, a merit list was published on 6/9/2021, in which the names of the petitioners figured as successful candidates. So they were also informed by the presiding officer by a letter dated 9/9/2021 that they have been selected as candidates and they were asked to report to the civil administration section with their original documents and certificates. However, later, White communication dated 6/2/2022, the petitioners were made to understand that the entire selection process stood cancelled and that a fresh process would be conducted for filling up the civil vacancies. The petitioners, aggrieved by this cancellation of the entire process, approached the Central Administrative Tribunal Guwahati bench and argued that they had successfully passed the examination and were selected as well. First off, they had the legitimate expectation of being appointed, but for no good reason, the entire selection process was cancelled. Perhaps on a stray complaint that the process was not conducted in accordance with the standard operating procedure and that there were many deviations in the selection process, as also likelihood of the entire process having been vitiated because of some senior functionary having demanded and accepted bribe money for clearing the names of candidates who had participated in the selection process. The tribunal, by order dated 27/6/2025, found that on account of irregularities committed in the selection procedure, which was not in accordance with the SOP for filling up of Group C civilian posts, such a decision was taken by the recruiting body. So that apart, the CAT was of the view that no right had accrued to the petitioners only by their having participated in the recruitment process. The petitioners had a right to be considered, but in the event of the entire process having been set aside, no indefeasible right was available with the petitioners against the recruiting body for the CAT to interfere in the matter. Without losing heart, the petitioners have approached this court against the order passed by the CAT. While canvassing the case of the petitioners, Mr. Ken Chaudhary, learned senior advocate, submitted that the CAT did not make a distinction between recruitment and appointment and wrongly held that the petitioners did not have locus to challenge the decision of the recruiting body to cancel the process. The petitioners had the locus as they were the participants in the selection process and were selected. Only appointment letters were required to be issued to him. For that purpose, they had been asked to report to the administrative wing, administrative office on a particular date with their original documents. this was a stage farther from, from merely being selected and being put in the select list to be considered for appointment. In that view of the matter, Mr. Chaudhary has argued that the order of the cat requires to be interfered with. The second contention on behalf of the petitioners is that the process was cancelled on a stray complaint over which some inquiry is said to have been conducted. The cat was not in possession of the cat. The inquiry report was never brought to the notice of cat. The petitioners, it has been submitted on behalf of the petitioners that the allegation of bribe taking could not be substantiated, and the officer who was named as having accepted bribe for clearing the names of candidates / participants as successful candidates, was treated honorably, and after his retirement was given all his post-retirement dues. No action was taken against any person. The contention of Mr. Chaudhary, therefore, is that though the authority lay with the recruiting body to cancel the examination process, but being a public body, such decision had to be an informed decision with necessary care, that a decision to quash the entire process would have nullified all the efforts which went into the recruitment process, as also would have frustrated the legitimate expectation of many successful candidates who are only waiting to be given their appointment letters. On these grounds, it has been argued that the decision of the recruiting body to cancel the process was not correct, and that the High Court ought to interfere. With respect to the locus of the petitioners, we are not in agreement with the opinion of the cat that without the petitioners having been selected and appointed, they did not have the authority to question the decision of the recruiting body to cancel the process. However, with respect to the extent of a candidate's right upon selection, we are of the considered view that till the time the petitioners were not appointed, they only had a right to be fairly treated and considered for the selection. Whether it selection. Selection in the final merit list of a candidate in an examination does not confer on him any indivisible right to appointment. The only right which gets accrued to him is the right to be fairly considered without any arbitrary decision making. Whether the recruiting body was justified in cancelling the almost completed recruitment process is something which has caught our attention. Should the respondents have cancelled the recruitment after completing the entire process and publication of the final merit list on a mere complaint, the records, however, reveal that it was not only the allegation of bribe taking by one of the senior functionaries of the respondents, but the process also was not strictly in accordance with the SOP with respect to dispatch of call letters, evaluation, and other aspects, other ancillary aspects in recruitment. What we also have considered seriously is whether this court could go into the sufficiency of the reason for the recruiting body to have taken a decision that cancellation of the process would be better in the circumstances. We are of the view that this decision making was in the domain of the recruiting body, and it would be exceeding the jurisdiction of this court in testing the sufficiency of the reason for taking such a decision. So far as legitimate expectation of the petitioners are concerned, this cannot override the authority of the recruiting body to cancel the recruitment process and order for a fresh process for filling up of the civil posts. Thus finding that the entire basis, thus finding that the entire premise on which the case of the petitioners rests is the legitimate expectation, is their legitimate expectation, the decision to cancel the examination being arbitrary and without any reason, and the petitioners having crossed the stage of selection, how have I begun the sentence?
Legitimate expectation that to cancel the examination.
We do not find, for the reasons stated above, any reason to interfere with the order passed by the CAT. With the order passed by the CAT. The writ petition thus is dismissed.
Deeply.
We make it cost easy. Dismissed. Next line, cost easy.
Item number 9.
May it please your lordship. The petitioner is aggrieved by the order dated 28/7/2025, whereby adverse remarks and sweeping and omnibus observations have been made. Your lordship may kindly peruse page 47.
Page 47.
47. The relevant paragraph starts from page 48. May I read your lordship?
Yes.
From the perusal of the record, it is seen that by
No,
order.
the page 58 you have said, no?
Is page 47 is the order.
47.
47.
I heard this. Yes. This is the order passed by which officer?
Additional Chief Judicial Magistrate, Kamrup Amit.
Additional Chief Judicial Magistrate.
Yes.
All right.
The relevant portion starts from page
So
50.
read the whole order.
Oh.
See, you are asking for expunction of certain remarks. Now, that more often than not emasculates the order. Therefore, unless we see that it is part of the order, part of the decision making, and unless we are satisfied, you see, while adjudicating a matter, there could be approbation.
True, Your Lordship.
And there could be condemnation as well.
True, very true.
Now, suppose we find, while dictating the judgment, we find that Mr. What is your name? What is his name?
Deori, Your Lordship.
Huh?
Deori.
Mr. Deori did not assist us properly. Now, in a softer way, we can say that we expected more from Mr. Deori. Now, that would not be stigmatic, and that should not be considered to be stigmatic. Nonetheless, therefore, we want to read the entire order. Yes.
Page 47, agree if Akira Nessa is present along with her learned and engaged advocate, Hart perused the records. NW issued against respondent Nasimuddin returned unexecuted with a report that the accused is not found at his house. It is also stated in the report the EO ASI Montu Korita made attempts to arrest the respondent, but from the Gao Pradhan, he got to know that the accused has gone to some other for his livelihood. Issue fresh NBW against the respondent Nasimuddin. From the perusal of the records, it is seen that by order 29/5/2025, the OC Goraimari PS was directed to appear personally on 36/25 to show cause as to why necessary action should not be taken against him for non-compliance of the order. The copy of the said order was also marked to Superintendent of Police Kamrup for information and necessary action regarding non-execution of the NBW issued against the respondent. Thereafter, on 36/25, it was learned from the PSI office that the copy of the order dated 29/5/2025 was misplaced and as such could not be sent to OC of Goraimari PS. However, the PSI Amingaon Court was directed not to be negligent in such manners. Again, and by order dated 36/2025, the OC Goraimari was again directed to appear personally today before the court to show cause as to why necessary action should not be taken against him for non-compliance of the order of this court, but the OC of Goraimari PS is present today and that too without any written intimation. What appears from the record is that the OC of Goraimari PS is quite aware regarding the order of this court, but still there to disobey the order of this court. This court cannot take the heedlessness and negligence of the OC Goraimari PS leniently, as the OC of Goraimari PS had repeatedly failed to appear before this court to submit his so-called reply despite of strict direction of the court. Hence, in order to ensure his appearance before this court,
Appears not to have found unconcerned. That's appears.
hence, in order to ensure his appearance before this court, I find it proper to issue BW of rupees 5,000 against OC Goraimari PS. ASI Montu Kolita Goraimari PS is strictly directed to execute the BWA issued against OC of Goraimari PS and submit his report on or before next date. Send a copy of this order along with BWA to ASI Montu Kolita of Goraimari PS for information necessary action. Also send a copy of this order of OC Goraimari PS for information necessary action. Record also reveals that in this case, now the Superintendent of Police Kamrup Aminga was also informed of the conduct of OC Goraimari PS by sending the copy of the order dated 29/5/2025 and 36/2025, but Superintendent of Police Kamrup Aminga was also shown his unconcern and laxity in this matter. Therefore, considering the alarming trend in this Kamrup district regarding the non-compliance of the orders of the court by respective IOs and OCs, the Superintendent of Police Kamrup Aminga is directed to take note of the matter and take necessary actions against all the police stations under his jurisdiction so as to ensure that the police officers.
It's 50,
Yes, Your Lord.
the last paragraph.
Yes, Your Lord. I am the SP, Your Lordship, Superintendent of Police Kamrup Aminga.
Read last paragraph,
Yes,
read the last paragraph.
Record also reveals that in this case, the Superintendent of Police Kamrup Aminga was also informed about the conduct of OC Goraimari PS by sending the copy of the order dated 29/5/2025 and 36/2025. But Superintendent of Police Kamrup Aminga also shown his unconcern and laxity in this matter. Now, in this case, Your Lordship, kindly peruse.
Just a minute. Now, if this word would have been, but it appears that Superintendent of Police Kamrup also has shown his unconcern and laxity, then it would not have been bad.
No, Your Lordship, 29, the order dated
What
29.
I'm saying, try and understand
Yes.
what I'm saying.
Yes, Your Lordship.
This is not a scurrilous remark. This is over the process of adjudication. Now, therefore, I'm saying that suppose you read it like this. But Superintendent of Police Kamrup Amingaon, comma, it appears also has shown his unconcern and laxity in the matter. I think it would have been diluted to a great extent.
Very true, Your Lordship. Very true, Your Lordship.
And so
But-
therefore, whether it would be justified to expunge this remark, whether it affects you in any manner whatsoever.
Yes, Your Lordship, because Your
The
Lord,
only reason that you can assign is that you were not there, you were not heard, no explanation was offered.
true, Your Lordship. But in this case, Your Lordship, the order dated 29/5/2025, this order reflects, Your Lordship, that the order dated 29/5/2025 was never given to me. And with respect to 36/2025, Your Lordship, I take an action. Your Lordship may kindly peruse page 57.
You have taken action.
Yes, Your Lordship, page 57.
Many cases are also expanded.
May I read, Your Lordship? Page 57. Please find enclosed herewith the copy of the court's order dated 36/2025 issued by the Additional Chief Judicial Magistrate Kamrup Amingaon in connection with case number DV 10019, which is self-explanatory.
What is this?
He has written to the officer enter.
No, what action have you taken?
I was directed to inform the OC, Your Lordship. That is what I have done.
Self-explanatory.
Order for a campus.
You have been, Mr. Superintendent of Police, you have been lax in the matter. There is nothing wrong about it. We can give you the law, we can tell you that in this circumstance, this statement is not very, very unwarranted. If the judge would have been careful, he would have said it appears that he was lax. What would you do to do that, or to remedy that? And laxity and being unconcerned is not going to affect his career, no?
No, but your lordship may kindly peruse page 51.
Not emasculate here.
No. Page 51, your lordship may kindly.
इससे कम क्या लिखेगा नहीं जुडिशियल?
May I respectfully submit your lordship page 51?
Page 51.
Yes, your lordship. Therefore, considering the alarming trend in this Kamrup district, regard.
Yes. Yes.
Therefore, may I read your lordship? Therefore, considering the alarming trend in this Kamrup district regarding the non-compliance of the orders of the court by the respective IOs and OCs.
That's a kind of concern of a judicial officer. We do it every day.
But
take note of
your lordship, but without it.
If we say that the lawyers don't come prepared, would you have it expunged?
No, your lordship, I completely understand. Sir, but only thing, your lordship, is that before passing of this order, at least an opportunity.
It should have been heard.
Yes, your lordship.
That's the only thing.
Yes, sir.
But we are not going to emasculate this order by taking away this thing. We'll only say that it will not be read against you in your service career.
That will be good. That will.
That's all.
Yes, sir.
And we'll expound the law. Correct?
Yes, your lordship.
But this doesn't shock our conscience. It is, if we were there, we would have written the same thing. If an officer in charge does not appear despite the orders of the court, and bailable warrant of arrest has to be issued, I think the Superintendent of Police is responsible as the captain.
True, your lordship.
He is responsible for captain. And what has the court said? Said that he appears to be lax.
Which is.
Doesn't say that he's incompetent, he's not fit enough to remain SP of a particular place. If such comments would have been there, we would have straight away removed it. It was not required. What law would you suggest to us? Long time back in one Raghubir Sahai and 9, these are two important cases for expunction of remarks. I have had the occasion to deal with such comments in the judicial orders. Therefore, we know, but they say that the person must be heard. Whether it was necessary for the court to say this while passing the order. Yes, it was. And therefore, bailable warrant was issued against the officer in charge. So we can't possibly, a judge would be left with no wherewithals to decide if he were to follow any particular mode of dictating the order.
My only respectful submission, your lordship, is this, before passing of this order, at least I should have been heard, your lordship. That should have been done in this regard.
Mr. T. Deori. We have heard Mr. T. Deori, learned advocate for the petitioner. The petitioner, who is the Superintendent of Police, Kamrup, Amingaon. Against whom? It is submitted, an unwarranted remark has been made in the order dated 28/7/2025 by the learned Additional Chief Judicial Magistrate Kamrup Amingaon in DV case number 100 of 2019. The prayer of the petitioner is to expunge those remarks. From the perusal of the order dated 28/7/2025, it appears that the learned presiding judge was not happy with the conduct of the officer in charge of the Goroi Mari police station, who was directed to appear personally on 36/2025 to show cause as to why necessary action ought not to be taken against him for non-compliance of an earlier order of the court. The copy of the said order was also marked to the SP/petitioner, SP Kamrup plus petitioner for information and necessary action regarding non-execution of non-bailable warrant of arrest issued against the accused person plus respondents in that case. However, on 36/2025, the date fixed, it was learned that the copy of the order dated 29/5/2025 requiring the presence of the officer in charge of Goroi Mari police station was misplaced, and therefore there was no appearance. Later, the officer in charge of Goroi Mari police station was directed not to be negligent in the matter. Still, the officer in charge Goroi Mari police station did not appear before the court, forcing the court to issue a non-bailable warrant of arrest against him, to issue a bailable warrant of arrest against him for procuring his attendance of the amount of rupees 5,000. Of the amount of 5,000. While concluding, the learned judge wrote as follows. Page 50 of the brief. A to A. Quote that in italics. From a perusal of the extracted paragraph of the order passed by the learned additional chief judicial magistrate, it is whichever of the learned judge, it would appear that she has asked, it would appear that the comment on the superintendent of police / the petitioner, the superintendent of police Kamrup Amingaon / petitioner, is only to the extent of his remaining unconcerned in the matter and displaying laxity in the administration as also in the execution of the orders of the court. This, to our mind, is not stigmatic or disproportionate to the fact situation in the case. To the fact situation in the case. Next, we wonder whether it could be called an adverse comment on the petitioner. True it is that any adverse comment against a person ought to be eschewed in judicial orders if such comments are not necessary for the disposal of the case on facts. This proscription is more applicable for persons who are not the parties to the proceedings. The only justification for any comment, any adverse comment in an order / judgment would be its relevance and the necessity for adjudication of the case. even in that case, the person slash institution commented upon has to be given an opportunity of placing his version on record. Next, the line of judicial decisions over the subject would require another reason to be factored in by a judge deciding a case, namely whether remark in the process of adjudication would serve a public or legal purpose, and that it should not merely be a mechanical act of cracking a whip on such person or institution. Stop. It cannot be lost. Next, it cannot be lost sight of that while adjudicating a matter, there could be condemnation and approbation as well. Stop. It is not expected of every judicial officer to follow any special way of couching his slash her orders, and a judicial officer has to be given complete liberty to decide a case. Stop. Many a times expressions would depend upon the felicity of the language possessed by the concerned judge, or the fact situation, or some other circumstances where a judge might not even have intended to cause any harm to the person concerned. To the person concerned. Stop. A judge, but must be free to express his mind in the exposition of the case before him. Stop. Judicial functions cannot be discharged effectively if a judge were to conform to any particular expression we find that in this particular case, the observation against the officer slash petitioner is not very unmerited and undeserved. But then, before making such comment, we are of the view that the superintendent of police slash the petitioner ought to have been called to the court. So stop. The records reveal that the petitioner had communicated to the officer in charge about his obligation to appear before the court, as also of executing the warrant of arrest against the accused person. Accused person. Terming the conduct, terming the conduct, however, terming the conduct of the petitioner as lax and unconcerned in this context does not appear to be to us to be stigmatic or irrelevant or unjustified. Or unjustified. We refrain from expunging such remarks against the petitioner from the order sheet, only for the reason of not emasculating the order of its content and reach. Content and reach. At the same time, we also caution that a judge has a correlated duty imposed upon it to show some respect to other, to show some respect to the officer or other parties to the dispute. Because judicial restraint and discipline is imperative for an orderly administration of justice. Orderly administration of justice. All that we can order is to direct that such observation against the officer shall not percolate in the ACR of the officer in future, and would not be read as an adverse remark by a court in his service records. With the aforementioned directions and observation, the reputation stands exposed.
I'm very grateful, Your Lordships.
Item number 11.
Will come after some time.
Item 11.
Yes. Yes.
My Lordships. But the petitioners agree, my lord, against them the non-evicting the my lord, illegal enforcers, my lord. They recently enforced, my lord, a village of my lord, roadside land of the village, my lord. There's that, to that extent, my lord, there's a report, my lord, and have a look, my lord, page 14, my lord.
Page
14. The report submitted by the circle officer to the district additional commissioner of revenue. The page 17 onwards, madam, these are names and addresses of all the addresses.
Now they are 19.
Page 17, madam. They have enforcement on more than 18 because of that, madam.
Yes, who appears for the respondents?
Actually, time for the revenue department, Your Lordship. The revenue department has already written to the deputy commissioner, Your Lordship.
No. Don't tell us all this. Now, who is the district magistrate of that area? Has he been made a party?
My lord.
Yes, yes.
District commissioner.
District commissioner.
You call it district commissioner. Who represents him? So what are the things are on your platter that they have given you this? Look at the effort of the petitioner. How would you remove the encroachment? Giving them their due, their rights. Have you issued notice to them?
Lordship grants me a few days time.
But then look at this, the report. First time, it has been listed for the first time, that's all right.
Yes.
But you must be getting the brief earlier, no?
Look, comes to us.
This PIL has been filed against local inhabitants, against people, against persons who have illegally encroached on government land in Samoguri Revenue Circle. In fact, the issue was brought to the notice of the district administration earlier was showing interest in the matter, a report was called for from the circle officer, who after conducting an inquiry submitted a report confirming the allegation of the petitioner that large portion of the government land has been encroached upon. In fact, the report of the circle officer identifies the names of the illegal occupants slash encroachers who have who are in possession of approximately, who are in unauthorized possession of approximately 18 bighas of land. Okay. MS Sumitra Sharma, learned government advocate Assam, submits that on the next date should inform the court about the action taken by the district administration regarding such encroachment. Let this matter come up for consideration on. We are giving you 3 weeks. Have it removed, serve a copy. Give them the necessary notice that you're an encroacher. Don't just push them off. Give them, we are keeping it after 4 weeks. Give them notice. We are not, I mean, there must be some anti-encroachment act here. Is it available or not?
There is your
Which act is that?
Assam Land and Revenue Regulation 1886.
So there must be some provision. Yeah, the sub-district magistrate is supposed to give notice. The notice is to be responded, and then 15 days time. There is a process.
Yes.
Now follow that process and act on the report of the circle officer. And please inform.
Deep level.
22nd September. Item 13.
Yes. Nobody appears on behalf of the petitioner. Let's this matter for consideration on. You're appearing for whom? Respondent whom?
Deputy Commissioner, I think Southwest DM District Magistrate.
Respondent number 1, your words.
You're appearing for state of Assam.
I'm for the Revenue Department, yes, Lord. For 1.
Yeah, nobody appears on behalf of the petitioner. The counsel for respondent number 1 / state of Assam is present. Let this matter come up for consideration on after 2 weeks.
15-9. Item 14.
Here, your lordship, we have put to challenge your lordship. Rule 279A of Assam Excise Rule, your lordship.
Rule 79A.
279A, your lordship.
Where is that rule?
That, your lordship, I have quoted at para 8, your lordship, the rule.
Para 8 of your petition.
Petition, your lordship, page 9.
Read.
May I read this? The state government notified the Assam Excise Amendment Rules 2025, by which certain amendments were made to Assam Excise Rule 2016. By the said amendment, Rule 279 was given following shape. Subject to fulfillment of the eligibility criteria for grant of IMFL retail off license, the existing IMFL on license in rural areas shall have the option to apply.
Is a shop.
On your lordship, where it can be
Consume.
consumed.
And
Consumed.
off is only sale.
Only sale.
Okay.
Now, your lordship, existing IMFL on license in rural areas, your lordship, shall have the option to apply for conversion of their existing IMFL on license to IMFL off license on deposit of application fee as prescribed under Rule 113. Such conversion shall be allowed by the district collector with the previous approval of the excise commissioner on deposit of applicable license fee for IMFL off licenses, provided that proposal for such conversion on IFL on license to IMFL off license in rural areas shall be submitted by the existing IFL on
This permission is not there for urban areas.
other urban areas, your lordship. That's why, your lordship, we are aggrieved by this, your lordship, because your
There
lordship,
could be a reason behind it, no?
what could be the reason behind that
The
is
reason
not
we can tell you,
lordship.
the reason we can tell you that there's not much footfall of customers in the rural areas.
No, your lordship.
And rural areas, people would like to sit in their homes instead of people in urban areas where they would like to sit there.
Lordship. That may, but your lordship, that is not discernible, your lordship, because your lordship will kindly see, your lordship, the proposal, your lordship, of
No,
this.
when the license, not like that. When the license is granted, is there any distinction or difference in the
No, your lordship.
fee with respect to urban and rural?
No, so far as fee is concerned, there is some difference, your
So
lordship.
therefore, this distinction has been made.
Distinction is there for to that extent, your
It's
lordship.
for the state and excise department.
I'm appearing.
What is the rationale?
My lord, for that I have to take instruction, but whatever I could gather yesterday, my lord, it's that, my lord, that there was a conscious decision taken. that-
Conscious decision, all right,
that,
authority, all right, plenary powers to legislate, all right,
Yes.
everything is all right. They have not questioned that.
Reason,
They question it on grounds of reasonability.
yes, reason is perhaps, my lord, this will, that on shops in rural areas might pollute the social environment, my lord. That pollute the environment there in, my lord. That's why
It's not.
urban people, my lord, they're not maybe more
That-
mature
that
drinker. my lord.
That distinction is very illusory.
Well, come up with response, my lord, but otherwise, my lord, it's law is settled, my lord, there cannot be any fundamental right to trade in liquor. Kotai
The-
distillery.
The petitioners are holders of on shop license in urban pockets of Assam. They seek to challenge the constitutional validity of Rule 279A of the Assam Excise Rules 2016, which provides an option to the licensees holding on license in rural areas to convert their licenses into off licenses. Semicolon, which benefit or option has not been extended to the on-shop licenses. Licensees situated in urban areas. The contention of the petitioner is that this is selective. This amounts to selective treatment based on arbitrary and unreasonable grounds. The further contention of the petitioner says that both on licenses in rural and urban areas are given by the same authority under the same legislation and are governed by the same set of rules. The parent law does not make any distinction between urban and rural on licenses. Thus, any such illusory distinction created by way of amendment would not muster the test of reasonableness. Though the Learned Counsel for the Excise Department, though Mr. P.N. Goswami, Additional Advocate General, and SC and Standing Counsel Excise, Department of Excise, has tried to explain that this distinction is out of a conscious decision, keeping in mind that on licenses in rural areas would have the potential of congregation of undesirable elements in village pockets, which would spoil the social atmosphere. Prima facie, this does not appeal to us at presently. However, Mr. Goswami submits that he will file a detailed affidavit defending the legislation, defending this piece of legislation by the next date. 3 weeks?
3.
Deeply obliging.
19-9. Item 15 and 16.
Maybe long.
Yes, that's very funny.
The applicant matter regarding the my lord area salary. My lord. The-
1 second, let me see.
Payment and volume. These two orders and kind of a continuing and double not paying them. No, so I think they can already been issued on March.
No, sir. No, sir.
See, this one, because earlier there are two orders. I order dated 22/5 and in fact there are petitions.
Yes, what is your stand?
My lord, the department has,
Don't tell us that this is barred by limitation.
no, my lord, I am not on
continuous-
that, I am not on that part, but my lord, by, in terms of the judgment, the
Anyway, what is the current status?
current status is that, my lord, in this petition, there are 15 appellants. Out of 15, 4 have been already paid their remuneration, my lord. And in respect of the 11, my lord, the process is on, my lord. So they have got a budgetary,
Perhaps 77 lakhs 46,000 has been disbursed.
Yes,
Yes.
yes, 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 your lord.
yes, my
7
lord.
lakhs 46,000
Yes.
has been disbursed.
Yes,
My brother could find this communication in his records.
My lord, actually, there were more than thousands of,
Have you distributed this amount amongst the appellants? The petitioners?
yes, 700, 7 lakh already.
yes, my lord, some of the female attendants have received their wages, my lord. In respect of the 15 appellants in this writ appeal, my lord, 4 of them have already been paid.
Who are they?
My lord, appellant number 6, 7, 8 and 9.
Petitioners number 6, 7, 8 and 9.
Yes, my lord, in appeal number 29.
From Sunitpur district, my lord.
297.
Yes, my lord.
Yes.
Sunitpur district, my lord, 297. And in respect of the 11 appellants, my lord, the process is on, my lord. They have allocated the budgetary provision. So, my lord, probably by the end of September, it will be done, my lord.
Mr. D.P. Bora, Learned Standing Counsel for the Health Department, at the outset submitted that some of the writ petitioners have been paid the amount due to them by virtue of the court's order, whereas the process is afoot for making payment to others. For the aforesaid purpose, a reasonable amount has also been released by the government. And it is expected that by the end of this month, by the end of
September.
by the end of September,
Yes.
by the end of the September month, by the end of September, all the petitioners shall be paid their dues.
Yes.
List this matter on after puja holidays में date लग गया.
Deeply obliged, my lord.
Well, so far item number, my lord, appeal number 71 and this judgment is same, my lord.
Same, huh?
Same.
Common order.
Yes, Lord.
Obliged, my lord.
22nd October. Item 17.
So the second service pension claim, earlier version while the material listed, the law is directed us to produce the Supreme Court, civil issues as taken up by Supreme Court. And the stay order is passed, last stay order as the communication, it was listed yesterday for the Honorable Supreme Court and it is deferred to 26/8/2024, 25.
Which issue is pending before Supreme Court?
The
Second
second
pension.
service pension,
The issue, the land council for the petitioner has informed this court that the issue with respect to the second family pension for persons enrolling themselves as defense security corps is pending before the Supreme Court, where the next date is
It's 26/8/2025 as.
8/2025. First off, let this matter be listed after the disposal of the aforementioned case, namely SLP number so and so, on October 5.
17 October.
Yeah, take the details from the order.
Item 18 and 19.
May it please your lordship.
Yes, sir, what is the matter? It's a huge brief.
The matter relates to, my lord, caste certificate.
Okay. Yes, Mr.
Yes,
You'll have to give us some background.
yes. The factual background.
Your Lordship, I appear for the respondents in this case, my lords.
Yes.
2 and 3 in item 18, my lords, and 6 in item 19.
Yes.
My lords, I was all scheduled to come and assist your lordships personally, my lords. But
Yes.
there was a call by my colleague assisting counsel that my learned friend would not argue the matter. Be that as it may, my lords, let my learned friend finish. I will come and assist your lordships, my lords, physically tomorrow or on Friday, my lords, if it's not inconvenient, my lords.
Then
Because-
let us keep it on a day when you're
Because-
here. You also are here and
Actually, my lord, we requested for some accommodation. They said they can't agree. Then we have no option but. to-
No, my lords, I thought that the agreement was arrived at, therefore I had to cancel my tickets, my lords.
Hmm.
I was all scheduled, but I don't know when. I
let's
don't know.
keep it
This
on
is-
some date next week. No, next week, Nick. Where I'm coming back, man. This is August. September.
My lord, not on next Monday, any other.
No, we're just telling you. Today is what day? Not next Monday. Next Monday is
25th.
that's holiday.
Oh,
And then 26th, 27th, I'd be off to Nagaland.
Well.
So I think it has to go to 1st of September or 8th of September. What suits you?
My lords, is second possible, my lords?
Yeah, it is possible.
Very well. 2nd of September then.
As jointly prayed for, list this matter. List both the matter. List both the matters. There are two of them.
two of them.
List both the matters on 2nd of September.
Yes.
As jointly prayed for, Litana. 2nd of September. What is this matter about? Just take 2 minutes.
Yes, my lord. I will be very grateful to assist your lordships, my lords.
A caste certificate was issued in favor of a lady, my lord, that was rejected by the state level scrutiny committee. That rejection was challenged before the learned single judge and learned single judge was interfered with. Relying upon, my lord, Ramesh Bhai Dabhai. But our case is, my lord,
Relying upon Ramesh Bhai Daba, which says if the mother is a scheduled
intercaste marriage.
scheduled tribe, then 3 aspects have to be seen. Otherwise, also we
There is a rebuttable presumption that.
Your lordship has made our task very easy, my lords. Your lordship is fully aware of this subject, my lords.
No.
My lords,
Yeah.
my lords,
We often get such opportunities
Yes.
to decide.
Yes,
with
my
such, disputes about caste status.
Correct. So, Malad, the learned single judge in a very detailed order, relying on Article 14 and Article 21, Malad, has given a finding in my favor and then remanded the matter back to the screening committee on a very limited aspect as to prove as to whether I am part of that society, etc., whether I've been accepted or not. Only to
That's
that
it.
extent.
So has it been left open-ended or has the SLC, state level
Well,
committee?
having laid down the parameters, my
And
lord,
then the
matter has
remand,
been-
you say that the remand is overloaded. Have you questioned that?
Yes, yes.
Have you
my lord.
questioned that
Yes, yes, my lord.
remand?
My lord, in fact, in my humble submission, para 48 of Ramesh Bhai was misconstrued by the learned single.
Okay, we'll see it on that.
Yes,
Yeah,
yes.
that's
yes.
a.
That was a question which the Honorable Supreme Court put onto them itself. Now that has been held to be as if a ratio. The ratio is paragraph 53 and 54, where it says it will all depend upon the facts of each case. Yes, there is
Correct.
a
That's
rebuttable
exactly
presumption,
exactly
but
what
that
the single
presumption
judge
is
has done,
invalid.
Malad.
All
And
right.
item 19, Malads, is a slightly different matter where he has filed a petition saying that a criminal prosecution should be filed against me because I have given false evidence, etc. We'll deal with it on the second one.
Oh, on 2nd of September.
Yes.
Item 21.
Ma'am, please, Your Lordship. My lord, as per the last order, my lord, the state need to have filed their affidavit.
State has filed the affidavit.
No, I have not received any copy.
Lordship,
Yes.
I'm the standing counsel for the department, so on the last occasion, government advocate has appeared. My name was not reflected and copy was also not served upon us. So I have received a copy 2 days before from the government advocate, from the department actually. So government.
What's your name?
MM Kotoki, Lordship, for Animal Husband and Veterinary Department. Lordship, we have already filed our affidavits in writ petition, Lordship.
You want a copy of the writ petition?
Yes, now I have collected from the government advocate.
That's right. So you have a copy.
Now I have.
Why do we saddle him with the additional responsibility?
No, Lordship, I have the copy.
Have you got instructions in the matter?
Lordship, no instruction at all, Lordship, as I have it 2 days back, Lordship. Only my concern is that, Lordship, we have already filed our affidavit in the writ petition, Lordship. I'm only relying on that.
That is not the issue, my lord. Issue is another, my lord,
The
another
government has
decision
taken
is
a
there.
decision in case of similarly situated persons,
Rate of
catering them.
On their
Yes.
own.
On that point, you have to inform
At that
us.
point, I have to take instruction
what we are
from the
saying, no?
department, Lordship.
That law we understand.
Yes.
Unless in catered, unless you are put in the feeder cater, you can't possibly have a right to
Yes.
promotion, right to have your list in the gradation list, your name in the gradation list. That we understand. But in a case of this kind in Assam, where there were more than thousands of, provincialization and, same post, but not regularized on the same post. It was regularization on the specific supernumerary posts. So whether that would be all right. Service jurisprudence says that it should be done. They must be put in that feeder cadre. Otherwise, there is no great fun for the persons. Perhaps your government is taking interest in the matter. You find out and tell us.
I will.
Rate of
Lordship, 1 week time, I'm.
MSM Kataki, learned counsel for the respondent state, seeks some more time to put in, to inform this court about the decision of the government, in case of similarly situated persons for encadering them and putting them in the gradation list and thereby in the feeder cadre for promotion to the higher post. Re-notify. You have asked for 1 week, we give you 2 weeks, but give us concrete information after 2 weeks.
10 September. Item 22.
In this case, my lord, I have prepared the affidavit and send it for vetting. Within 2-3 days, it will come, my lord.
What is this matter? Judicial service.
Judicial service.
Mr. Chaudhary, you'll have to give us 2 cases from Bihar and Delhi.
Yes. But there's a latest
you have
development.
There is
Dheeraj
a
more
latest
which
development,
gives-
my
Well, there's a latest
already
development.
referred to the full.
There is a reference to the
To
Supreme Court.
the,
In
again, the
Supreme Court.
point involved in this case already, my lord, pending before the Honorable Supreme Court, and now it is referred to the full bench, my lord.
So Lordship should kindly come to page 14 of the order, Miller. At para 22, article 233 is quoted, Miller. Then para 23. Upon a perusal of the text of article 233(2) and in the light of the submission advanced by the learned counsel for the parties, and on interpretation of the provision, we are of the considered view that following two issues are substantial question of law as to the interpretation of article 233(2) of the Constitution. Whether a judicial officer who has already completed 7 years in bar being recruited for subordinate judicial service would be entitled for appointment as an additional district judge against a bar vacancy. And second issue, kindly skip over to the next page, my lord. Whether eligibility for.
That is the issue, no?
There is that.
That is the issue. Therefore, we have.
And my lord, without formulating this issue, my lord, in that judgment, that
No,
is,
we
my
can't
lord,
do it.
Dhiraj More.
Dheeraj more.
And the basis of
Yeah,
Tiraj, my lord.
But there is a slight difference, my lord. In our case, the rule permits.
But here,
In Dhiraj More was Dhiraj
No,
More.
your rule means nothing to us when we are dealing with 233.
No, my lord, subject to the rules.
It is subject to the.
Yes.
Okay.
Subject to the
Okay.
rules.
So in this case, this person, the
my lord,
officer,
actually,
he-
on the
he
day
thought-
when she applied,
she
she was
was
not
an
a
advocate.
judicial magistrate. Because he was,
judicial magistrate.
yeah, he, civil judge, she was recruited to grade 3, my lord. She applied for both grade 3 as well as grade 1.
When did she apply for grade 1?
On the date when she applied for grade 1, she
So
was a
therefore,
lawyer, she was an advocate having completed
That's what
7 years of
my
practice.
brother is saying. Therefore, she was an advocate on the date when she applied
Yes,
for grade 1.
yes.
but on the date of appointment, he was not in.
Date of appointment is nothing, date of application. Let's see what the Supreme Court decides.
Yes. No, well, I think it will be too long, my lord. Supreme Court may take.
What do we
Only
do?
thing
Now?
is,
Once the matter is in.
So my affidavit is ready, my lord.
Mr. Chaudhary, Mr. Chaudhary, let
Lordship
her
will call it after 4 weeks. Let us see.
let her continue at grade 3. We will
He
say.
is continue. He is still continue.
Brilliant student, my lord.
Has to be.
Yes.
And I am always in favor of such.
Yes,
persons.
yes.
These technicalities should not come in.
Yes,
the way.
yes.
We need such officers. In fact, but let the law take its own
Right.
course. Here, the petitioner had applied for being appointed, applied for being considered for appointment for grade 1 and grade 3 post in judiciary simultaneously while she was an advocate. The result of grade 3 examination came out early, where the petitioner was returned successful. Stop. After she joined the grade 3 service, the result of grade 1 examination also came through, in which the petitioner was successful. She was not allowed to join.
Yes.
She was not allowed to join for the reason that she, at the time of appointment, could not have been taken to be a person from the bar, and therefore, her appointment in that case in grade 1 would not be in accord with Article 233(2) of the Constitution of India. Stop. The issue is this issue, namely whether the eligibility for appointment as a district judge is to be seen only at the time of appointment or at the time of application or both, is pending before Honorable Supreme Court in Civil Appeal number 3947 of 2020. Let this case be listed after 4 weeks.
Yes.
After 4
I
weeks.
think some urgency has been shown by the Honorable Supreme Court. Maybe it will come up these days.
After 4 weeks on so and so.
Yes, yes. Deep level.
24th September. For admission, item 23.
Pursuant to the order dated 13/3/25, we are filing our affidavit today, placing on record the updated status regarding detection of quack doctors in the state of Assam.
We are also filing our affidavit today. The petitioner was also directed
You're filing it today.
Yes, sir.
This was directed to be filed when?
on 13th of March.
13th of March.
Yeah.
Pursuant to the order dated 13th of March 2025, the lead counsel for the petitioner as also the state proposed to file the affidavit asked for today in the registry. The affidavits would include information regarding the action taken against the quacks by the anti-quackery units. The affidavit of the petitioner would certify whether any such step has been taken and would also include suggestions to be undertaken by the state for identifying quacks in the entire state of Assam and prevent them from taking advantage of the gullibility of lesser educated people especially in the rural areas. List this matter along with those affidavits on after October.
1310.
Many.
Item 24.
Right, this your lordship. Lordship, my senior is engaged in another court.
Louder.
He is engaged in another.
Who is engaged in another?
My senior is engaged in another court, lordship.
You want a Passover or you want adjournment?
Adjournment, lordship.
Of how many weeks?
Next week. Next week, lordship.
2 weeks. As prayed for.
17 September.
Lordship, if possible, before 15 or after 17.
After 17.
15 October.
Oh, please, Lord.
Supplementary list, item 29.
This IA is for expeditious hearing. But this case has a checkered history, Miller. 3 Chief Justice have heard this matter and has won some.
No.
Chief Justice Dhulia almost heard it.
Oh, it's continuing for such long time.
Yes, my lord. Then, my lord, we submitted our written argument. Then at that stage, a news came. So matter was released. Same happened with Sandeep Mehta. Honorable Chief Justice Vijay Vishnu also. So that way I would like to hear it bit late. Hello, there is some urgency.
Yes.
Because in the recruitment, we are not getting the benefits.
Mr. Chaudhary, we can promise you that we will not leave it like this.
Yes.
We will hear you.
Yes.
But you'll have to give us time in October. You'll have to agree for a date.
Second half of September, Miller, later part of September.
September would be difficult. For the reason that there will be many other matters coming up. In the first week after the Puja holidays, I don't know what you call Puja holidays or what.
Yes, we call it Puja holiday. My lord, will it be, if it is not inconvenient, my lord, last week of September, my lord? Because what had happened, in fact, we filed this IA where some posts were advertised.
Last week of September, Mr. Chaudhary, there would be some difficulty.
Okay.
For the reason that the important functions are coming up.
Okay.
And I think.
My lord, then our court reopens on.
You tell me any date from 13th of October.
Let it be on 16th of October, my lord.
16th of October, we will assign a priority. We will start hearing.
Yes.
Please keep your written arguments ready.
It's ready, handy. It's already submitted. It's in the file.
To the file?
Yes.
Okay. Then we can, and how about the other side?
Both parties.
They have also done it, my lord. That's why I said, my lord.
All right. Okay, this interlocutory application has been filed for assigning an early date of hearing of this case, hearing of the writ appeals. For the reasons stated in the application, the prayer is allowed. Let the concerned writ appeal, there's only one. Let the concerned writ appeal be listed for hearing in priority on 16th of October. Within first 3 cases.
Daily list for hearing, item 26 to 28.
Yeah, adjournment. 26 to. The same thing about Karbi Anglong.
My lord. The lordship may kindly come to the last order.
Some other day, Mr. Borgoy.
Well, in that case, can it be fixed after 9th of September? After 9th of September.
Why not? We can give you a hearing sometimes in the week commencing from 22nd of September.
22nd of September.
22nd of September? 23rd?
We fix it on 23rd of September.
23rd.
Let this matter come up.
Well, can we ask for giving us permissions for all of us, giving a convenience compilations?
I think you'll be doing a great job by doing it.
What of us will exchange it also in that?
Yes, you exchange and you give it to us. But before 23rd.
Oblige, your lordship.
Let this matter. How many of it?
3 or 3 other.
Let these matters be listed for admission. Be listed for hearing on 23rd of September.
Oblige.
In the meantime, convenience volumes exchanged between the parties shall be filed.
Supplementary list for hearing, item 33.
This appeal has been filed by the state now.
Yes.
And method pertains to departmental proceeding manner. We issued a so cause notice to the delinquent manner, which was found to be vague. So we supplemented it to add an additional so cause notice. So Honorable Single Judge has said that we don't have that power and directed us to proceed with the vague so cause notice.
But here I appear for the party concerned.
Yes.
Now, as far my instruction goes, my lord, within the morning, the respondent has said that already in the first so cause, which has been issued, now that has been dropped. And it was in the inquiry officer appointed, presenting officer, everything was done. And that has been dropped. That's what my instruction is.
That's good.
So, yes.
For you.
Yeah, that's why I'm saying now the argument which was made before the learned single judge in respect of the second so cause which has been issued, a fresh so cause has been issued. That's how we were aggrieved. When the first so cause was pending, we file a reply. Then the second so cause, fresh so cause notice. That's by an affidavit they have come to. There's an affidavit, fresh so cause notice has been issued. Whether it is permissible.
I think it should have been dropped.
Yes.
Fresh should have been issued. But there are case laws which say that if it is vague, if it could be supplemented, it could be done. But not by way of plugging the loopholes in the first one after receiving the reply of the delinquent.
Right. And my reply.
So what do you say, Mr. Das?
Yes, my reply, which is my lord.
Yes.
I replied by the first so called and documents which was relied by me.
That's
that
right.
was that is the relied document they have. That is
That's right. So today your
what my instruction is that let them tell the court what has happened to the first so cause and what has happened to that.
Yes.
That instruction I already had, my lord. Pursuant to the Honorable Single Judge order, my lord, inquiry officer proceeded, but in the meantime, we have preferred this appeal. There is a stay in the appeal. So an order was passed that everything will be kept in abeyance till the appeal is decided.
No, we will not decide the appeal if you have taken a decision.
No, we have not taken any decision.
You have not taken any.
Independently, they will stop the that second will be appealed.
Therefore, we hear it now.
My lord. Now, my
Mr. Das, you're ready?
Well, if it is not inconvenient any date which is convenient for this court.
Up to your convenience.
No, my convenience.
I'm always here. You people have to move from here and there. Mr. Das, I heard there was a bereavement in your family. I was
Yes,
at Litanagar.
I was prepared to go, My mother-in-law expired, that's why.
September.
In fact, my brother says that all of us were expecting you in Itanagar.
Yes, I
Because there were
also
many
really,
advocates, you should have been there.
but yesterday.
I know. We
No,
understand.
Yes, yesterday I was in Itanagar for one matter. I think it's the best in India, I'm telling you a lot. The High Court.
4 or 5 high courts that I have
No,
seen.
my lord.
I
yes.
think it's incomparable.
My lord, I know Honorable Chaudhary will know when I was in AG of Mizoram. That was my time when I was AG, and I thought that's the best. It's lovely, it is built up in white, like it's terrific. My lord, your lordship should go there. But I found Arunachal something more. More.
I sat there for 2 days, no?
Yes, I wanted to enter to Chief Justice Court, but it was dark, pitch dark. So I should not enter, and without permission of your lordship, I know.
The building, I mean, all stakeholders have equal right there.
A superb.
Except for the chair, everything is open to all the stakeholders. Chair also, it can be used in free time.
I'm sorry, my lord, we could have proceeded. I'm extremely sorry that, my lord, I couldn't do it today.
It's all right, the issue is very small.
Yes, very
Just
small.
get us 2 cases.
Yes.
The 2 cases would be, I forget, one Gunasekaran.
Yes.
There are some paragraphs which would answer, and the other is, I don't know what.
I will look into it, man.
All right. As prayed for on behalf of the respondent, re-notify on. Give a date.
September, I have heard that your lordship is.
No.
September, anything.
September, so we keep it in the last week of September.
Right.
24th of September.
24th of.
Oh, sorry. 26th.
25th.
25th of September.
25th. Yes.